Hello, thank you for joining our webinar on California's suitable seating law. Legal and Ergonomics Landscape is the title. My name is Andrew Sommer. I am a labor and employment partner at Kahn Maciel Carey at its San Francisco office. And our firm is a labor and employment boutique firm specializing in employment litigation and OSHA enforcement, among other areas. And we have webinars throughout the year. This webinar today is of particular interest to companies with operations in California or that want to be aware of the trends in this area to the extent it could impact the rest of the country at a later date. This webinar is unique in that we are partnering with another company, with JF Associates, Inc., and JF Associates is a consulting firm focusing on ergonomics and safety and health issues, among other areas. And with us today is Brandy Ferris-Ware, a principal engineer at JF Associates. Brandy is a board-certified professional ergonomist. She works on projects and cases involving the application of industrial engineering, ergonomics, and safety and health techniques for clients. We will start the webinar with a focus on the legal issues that I will present, and then that will be followed by Brandy discussing the ergonomics issues. This issue we're discussing today is an emerging issue, and we can say that it's already emerged now in light of a recent California Supreme Court decision. And we're going to walk through some of the issues related to suitable seating. Throughout the webinar, questions can be typed in that we can answer, and we'll leave some time at the end to answer those questions. Let's move into the agenda for today. We are going to first discuss the origin of suitable seating litigation, the legislative origin, that resulted in specific wage orders that then were litigated in the courts. We will also discuss in some detail the California Supreme Court decision in Kilby v. CVS Pharmacy that came down this last month that provides some clear guidance for employers and for plaintiffs' lawyers in handling these cases. And then we are going to discuss the role of ergonomic assessments. That will be addressed by Brandy. And then we'll move into some action items to be considered by employers. So let's first move to a discussion of the origin of suitable seating litigation. Now, the background of this issue is interesting. This provision regarding suitable seating in California has been on the books for over 100 years, but in different forms. Initially, suitable seating was legislative as a protective provision for female employees and also for minor children. Then eventually this suitable seating requirement became memorialized in wage orders in the state, and eventually that requirement applied to all employees, not just female employees. Historically, there was no penalty provision related to this seating provision, and there really wasn't much litigation over this. As background, the state has a number of different wage orders that apply to different industries, whether that be agriculture, manufacturing, professional workers, and the majority of them do contain a requirement regarding suitable seating. The primary requirement is that employers provide suitable seating for employees where the nature of the work reasonably permits the use of seats. Now, what that means has been the subject of debate and litigation, and that's an issue that has been fleshed out mostly in recent years. let's discuss the litigation of this issue. The Bright v. 99-cent only stores was a case that really expanded the suitable seating issue and propelled a tremendous amount of litigation. And how this arose was that, as I mentioned, there was no penalty provision associated with the suitable seating requirement. And we were aware of this on the books, but you really wouldn't see much litigation over this. And then in 2004, the California legislature enacted the Private Attorneys General Act, which is also referred to as the Bounty Hunter Law. And what it did, and it was a real gift to the plaintiff's bar and caused great consternation by employers, but it allowed private citizens, individuals, to bring suit against an employer alleging wage and hour and other labor violations. And what they could do is also seek the recovery of penalties, even if a penalty wasn't provided under the statute at issue. And those penalties would be $100 per employee for each payroll period for the initial violation, and then $200 per employee for the pay period for each subsequent violation. And so these could be nominal violations such as a pay stub not containing all of the required information, or a whole host of other potential wage and hour violations. The plaintiff's bar latched onto this and started to litigate under the Private Attorney General Act these suitable seating cases. And it wasn't until the Bright case where there was clear guidance from the appellate court on whether suitable seating could be litigated under the auspices of PAGA. Another point I did want to raise was that in addition to recovering statutory penalties, and these penalties, a portion of them must be given back to the state, and that's why it's called the Bounty Hunter Law, but also the plaintiff's bar can recover attorney's fees and costs. So you can just imagine the tremendous financial incentive that PAGA has provided. Now, the Bright case addressed whether suitable seating could be litigated under PAGA with all of these attendant benefits. The Bright case found that it was appropriate under PAGA to bring a suitable seating case. There was a Home Depot case that followed a month later that reached the same conclusion. And so essentially after this, the Bright case in 2010, just 6 years ago, that was truly the emergence of the collective action suitable seating cases. And in those cases, it's typically a class action as well as a PAGA-type collective action. So these cases over the last 6 years have addressed some of the considerations arising from the suitable seating requirement. And there's been a lot of discussion about the requirements and what they're perceived as. But the field hasn't been certain. And as a result, this issue recently got all the way up to the California Supreme Court, and we recently received a decision that provided clearer guidance in a way. Now, the California Supreme Court weighs in, and how this arose was from a request for certification of questions by the Ninth Circuit Court of Appeals. And the Ninth Circuit Court of Appeals is the federal court of appeals, and that court is not required to follow California appellate court cases on California law, but may consider them as persuasive. However, when it's a California Supreme Court decision, that decision essentially is the law of the land on any question of California law. And when there is an issue that on California law that oftentimes is going to be heavily litigated or is of great consequence, the Ninth Circuit can, and it doesn't do it all that often, but it can request or essentially ask questions to the California Supreme Court for them to answer that then would provide them guidance for cases that are before the Ninth Circuit. So what happened here? There were 3 issues that were presented by the Ninth Circuit in 2 companion cases. One was, what does nature of the work mean in the wage orders? What does reasonably permit mean? And does an employer or does the employee have the burden of proving that there is the availability of suitable seating? Let's start with the questions that were posed by the Ninth Circuit. Now, the Ninth Circuit had 3 issues that they presented. And again, what the language under the statute is whether the suitable seating is available when, or more specifically, whether employers are required to provide suitable seating when the nature of the work reasonably permits the use of seats. And what is the nature of the work? And in the question that the Ninth Circuit presented, they asked whether that referred to individual tasks or a range of duties performed during the work shift. As for reasonably permits use of seat, they asked what factors the court should be considering. And lastly, the Ninth Circuit inquired into the burden of proving the availability of a suitable seat. So the cases that were before the Ninth Circuit were 2 cases. One was Kilby v. CVS Pharmacy, and that involved a customer service representative, essentially a clerk, that had a variety of duties that included working the cash register, stocking, cleaning, things of that nature. The other case was Henderson v. J.P. Morgan Chase Bank, which involved essentially a bank teller that had some responsibilities outside of working as a teller at the counter. So this got to the California Supreme Court. The Supreme Court had this issue briefed. There were decisions, there were briefs submitted by the employees in these cases. They were briefs submitted by the employers. There was also a brief submitted by the Division of Labor Standards Enforcement, essentially the California Labor Commissioner. And the Supreme Court reviewed all of the different approaches that were being considered. And so they were looking at whether the nature of the work reasonably requires seating. And in looking at the nature of the work, they reviewed the employer's approach, which was a holistic approach. And they were advocating to consider the entire range of duties throughout the day. And that the focus should be on all of their tasks and those identified in job descriptions, titles, and that those should be weighed. The employees had requested an approach that was markedly different, that proposed that the court consider each single task performed by the employee and whether each task could feasibly be performed seating. And so the employee's approach would essentially allow a chair anytime a single task would allow for seating. The Labor Commissioner, however, took a different approach, and they looked at the job duties based on specific locations, and the approach of the Labor Commissioner in many different regards was essentially adopted by the court. And what the court found here is that the courts should consider the task performed at a given location for which there is a claim to suitable seating. So if an employee is working at various different locations throughout the day, you would look at each location and assessing whether there is a requirement to provide suitable seating. They rejected the holistic approach. They rejected the employee's approach of looking at single tasks. And they specifically stated that you look at a subset of an employee's total tasks and duties by location. All right, and then looking at the second issue, which is whether the work reasonably permits use of seats. The court spent some time on this issue. The court did note that nature of work and reasonably permit are essentially intertwined and that you need to consider both together. So when you're looking at the nature of work, you're looking at the nature of the work from a reasonable standpoint. What the court found was that in answering these questions, that they need to evaluate the sum of the relevant factors in making the seating determination. Whether the nature of the work reasonably permits sitting is a question to be determined objectively based on the totality of the circumstances. It's an objective test. You look at the nature of the work. You don't look at the employee's individual characteristics, for example, whether the employee can perform certain tasks. And the court looked also at, indicated that a consideration is the physical layout of the workplace. So you're looking. And another consideration was the business judgment of the employer. And the court found that the courts can defer to the business judgment of the employer in defining the duties of the employee, but they made the point of emphasizing that the employer's preference is not given weight. And it has to be something more than a preference. And in terms of evaluating the duties, the employer can keep in consideration the customer service component of the position. Whether there was a need to remain standing, for example, from a customer service standpoint, providing good customer service. And the court emphasized that you look at the feasibility of providing seating as well as the practicability, and that those are considerations that would offset the evaluation of the ability to provide suitable seating, and that I'll get into in a little bit more detail in a second. On the last question, the court found that for an employer to be excused from the requirement to provide suitable seating, assuming that the standard is met, that the work reasonably requires seating based on the nature of the work, the court found that for the employer to then claim that that suitable seating is not available, that is the burden of the employer, not the employee. This was not an issue fleshed out much by the court, or actually at all. And the issue is something that will surely arise in other litigation, but it appears to be what they're talking about is a situation where the position, based on the nature of the work, could require seating, but there's simply no type of seat that would be satisfactory given the nature of the duties. So what is the outcome of the Kilby decision? There is the emergence of a fact-specific approach, and this approach, based on what we were talking about, is it's looking at the subset of employees' total tasks and duties by location. So if they're working at the cash register, what are their duties while they're performed there? And evaluating all of them by location to determine whether it is feasible to provide seating. The same, for example, for a teller, like was encountered in the companion case. You're also looking at the actual task performed or reasonably expected to be performed. abstract characterizations are not considered. We're looking at a very specific factual approach and looking at what was done. In the past, employers would focus on job titles and descriptions. Those have a lot less weight now. You're looking at very specifically what's being performed at each location for the employer, and then as to each employee at issue, the specific locations where they're working. So what does this all mean? This is a highly fact-intensive analysis, and the result of this is that where you have a collective action, it is going to be a much more in-depth analysis of whether or not suitable seating is required for specific employees. One benefit potentially for employers is that an employer can argue that it would not be manageable to litigate these claims as a collective action because it's really going to depend on the individual employee where he or she is working at a location. So you cannot look at just one job title. You have to delve deeper and go into the specific locations and where people were working and what they were doing. And it may be appropriate suitable seating for one employee at one store but not at another. So that does provide the opportunity for employers to argue against class certification or a PAGA collective action based on this very fact-intensive individualized analysis. And then to recap, we're looking at the totality of the circumstances. You're not looking at just one thing. You're looking at all the duties by location. You're looking at the physical layout of the workplace. You're looking at the employer's business judgment. You're looking at the frequency and duration of the task that you're evaluating at that location. You're also looking at the feasibility and practicability of providing seating. And as I mentioned previously, the feasibility could be looking at whether it is even manageable to provide seating given the different tasks, some of which may require seating and some of which or may allow for seating and others that certainly require standing. And if a standing task would be if the sitting task would interfere with a standing task, that would be something certainly that could be considered. Also, the quality and effectiveness of the job performance would be considered in evaluating whether this is feasible and practicable. And again, it's the physical layout is a consideration. The employer defines the physical layout, but they certainly cannot set up the layout in a way that would prevent the employee from using a seat or at least claiming the right to a seat. Now we're going to move into the ergonomic issues. Brandy Ferris-Ware will be conducting this portion, and this will be in a separate recording on our website for those that want to listen to it. I did want to make one point, however, that this is a very significant decision by the California Supreme Court. It does provide some much needed clarity, but it's not real satisfying from the standpoint of employers that would like to have a bright line test that they could apply in numerous different situations. So really the upshot of all this is the importance of employers conducting assessments of their work areas and doing so from time to time as also updates to establish whether a seat can even be provided under the work circumstances for those employees. And so this assessment needs to be done by employees, and by employee, it can be done in a variety of different forms. It can be by an ergonomic expert. It can be by other in-house personnel. And that assessment can be used to both revamp operations to address the findings, as well as for use in potential litigation as a defense. Now I'd like to turn this over to Brandy.
Perfect. Thank you, Andrew. If you have trouble hearing me, just type in the chat box just so that we can make sure that you're getting good quality sound. Like Andrew said, I represent JF Associates, and based on Andrew's discussion, it may seem like it would just be simple to provide seats for all work areas and all tasks. So the question becomes, what if I provide seats for everyone? Well, while that is an answer, it's not actually the answer. Often when a chair is introduced to a task that it's designed to be performed while it's standing, and of course there's been no analysis or review of the work, we often see that injury risk may actually increase because of the use of a seat. This is because the amount of awkward postures of the shoulders and elbows and wrists typically increase. It also increases the frequency of those awkward movements. So we see an increase in the extent as well as the frequency. And then because you're changing posture, the amount of forces applied also change. And all of those can result in an increased risk of injury. If you were performing a task in a standing posture, let's say washing the dishes, and if we introduced a seat, either a regular seat or a high seat, so that we could now, in theory, wash those dishes while we're seated, without evaluating the workstation, of course, or the task, think about what postures you'd be using. If you had a regular chair, say you pulled one over from your kitchen table and sat it in front of the sink, the top of the counter would be closer to your armpits than your waist. This could cause awkward postures of the shoulder.
Can you all hear me? Is this just Brandy's line, or did we lose audio for everybody again? Can anybody hear me talking right now? All right, so the problem is on Brandy's line. Let's see if we can get that straightened out. Hold on one second.
Hello? Can you hear me?
I hear you, Brandy.
Okay. Perfect. Should I continue?
Yep, it sounds like everything's fine now.
Okay, great. So similar things could happen if you introduce this seat in an existing standing workstation without doing an evaluation. The most appropriate way is to determine if a task could be seated is through a thorough ergonomic analysis. So what is ergonomics? Ergonomics is the design of the workplace, equipment, machine, tools, products, environment, and systems while taking into consideration the human's characteristics. Ergonomic evaluations use scientific methods and models to review tasks in order to help reduce the injury risk and maintain or improve productivity. When it comes to seated and standing work, there are a series of established criteria by which workstations can be evaluated. A certified professional ergonomist, or CPE, that is one of us who has a certification through the Board of Certification of Professional Ergonomists, the premier certification body for all ergonomists all over the world, is familiar with these data analysis techniques and criteria. Now granted, some of these criteria are very simple, and it's just as simple as looking at whether heavy objects are being handled or how far apart the workstation is. Others, however, are very complex and require determining the internal forces of the back and whether using biomechanical, psychophysical, or other models, those forces are acceptable. We considered items such as these when our firm worked on the Garvey versus Kmart case and our other suitable seating cases. Ergonomic analysis can also evaluate the impact of the proposed changes. So if you're thinking about making a change, what is the impact to the injury risk? These analyses of scenarios are really important to ensure that any changes being made to the workstation, the layout, the tools, or even the tasks will not have a negative impact on the injury risk. So we're not increasing risk, we're decreasing the risk with these changes. Additionally, ergonomic evaluations can be performed in a variety of environments, including heavy and light manufacturing, labs, retail areas, hospitality, and offices. The court ruling mentions that analysis should focus on the actual work being done, and tasks should be grouped by their location. In ergonomics, we evaluate tasks by analyzing characteristics such as awkward postures, forces, repetition, duration, the workstation, and manual handling items, among others. This analysis identifies work-related risk factors such as excessive forces, awkward postures, high frequencies of movement, long task durations, and those risk factors related to materials handling. Keeping along the theme of tasks that we can all relate to, let's consider the task of doing laundry. A question we may be asking is, can we perform the laundry tasks in our laundry room at home seated? Several factors that would go into evaluating whether the task could be done, and if it could be done while seated or while standing. So in order to take a look at this, we first have to understand the nature of the task. The job of actually doing laundry involves a number of subtasks in the same work area or location, including putting the clothes in the washer, pulling the clothes from the washer to the dryer, and folding clothes. An ergonomic analysis of these tasks should be performed to determine if those tasks could be performed seated, and they would review all the tasks that were performed in that same general area. So everything you would do in your laundry room, would be considered for review. A similar method to understanding the frequencies, the duration, and the location would be applied to tasks in the same work location if we were evaluating a work task to determine whether a seat could be used. Ergonomic assessments include the evaluation of durations and frequencies, among other items. These include the duration of the total task as a whole, as well as the frequencies and durations of specific items and tasks, postures, and materials handling within the task. Back to our laundry scenario. Although we have a simple example, it illustrates the detail of evaluation that should be considered. The evaluation would review the total duration of the laundry task for one load, or how, if you went to a laundromat, let's say, how long you would be there doing several loads. And it would evaluate the extent and frequencies of awkward postures and reaches while you were performing those laundry tasks. Think about when you're loading dirty clothes into the washing machine. The type of machine will obviously make a difference. Some of us have front load machines, some of us have top load washers. This is true in the workplace too. The type of equipment being used matters. Think about it in a retail scenario. Even though many retailers use scanners, not all scanners are the same. Some are mounted in the workstation, some are handheld, some are mounted other places. The amount of space that they take up varies, as well as how they operate. So even though the task, say a cashier task, may be very similar in different environments and the goals of the job are similar, the equipment, the frequency of handling items, and other specifics may be very different. When you load the washer, you often have to pick up clothes from either a hamper or on the floor when you've sorted them. This would involve bending of your back or hopefully lifting from your legs and properly if it's a heavy load. Lifting these items, placing them in the washer. The placement in the washer would involve some pushing and reaching and pulling, as well as awkward wrist postures. So think about all the body postures that would be used or that you do use when you load the washer. When it comes time to add the detergent in the machine, that's also going to require some awkward postures of the shoulders and the elbows and the wrists. And think about if you use liquid detergent or a box of dry detergent that you had to pull down from a shelf, that includes significant weight, definitely more than 8 pounds. So again, you'll see wrist, arm, and shoulder movements associated with that. We could have similar discussions about the body postures, forces, repetition, and duration of tasks when we retrieve clothes from the washer and put them in the dryer, but I think you get the hang of what we're talking about. Finally, I think there's a third set of postures that you would use while you're folding. Are there different postures when you're folding t-shirts versus a set of sheets or towels? What's the frequency that you fold t-shirts? Do you fold many more of those than other things? Is the folding done in the laundry room or some other area? When the laundry's done, do you have to carry it up the stairs? Do you use a basket, or do you just carry the load? Do you push them in a cart down the hall? How would these frequencies and durations and forces change if you went to a laundromat and did 5 loads at once instead of 1 load at a time like we typically do at home? All of these considerations and more apply to the evaluation of workplace tasks, to the duration as if a seat can be used, and evaluate the risk of injury, including the things we've talked about: repetition, force, postures, duration, and frequency. A good ergonomic evaluation will consider these items and other work-related injury risk factors. The court ruling indicates that an evaluation should include tasks performed at a single location. There are so many considerations that are related to location, including understanding how many tasks are being performed by different individuals and characterizing the risk factors for each employee and each task. And that's important when determining whether seated work is appropriate. Other questions that you might consider include, is the task being performed in a place where reaches and weights are minimal and there's adequate space for knees and feet while seated? If so, this may indicate a seated posture could be appropriate. Likewise, if employees are working with heavy items, the work areas are spread apart, and there's not enough room for your feet and your legs while you're seated, these issues could lend themselves to a standing task. So let's think back to our laundry example. If you tried to introduce a seat for the task of pulling laundry out of the washer or the dryer, would you be able to sit down and reach into both machines and function effectively? Or would you need to stand up to turn on the machine or press the buttons? Do you fold laundry in the laundry room, or do you carry it to another location to spread out and fold the laundry? And if so, what does that area look like? Similar considerations should be made when introducing seats into a work area. Another consideration within the ergonomic evaluation, and one that has significant impact on how tasks can be performed, is the physical layout of the workstation. From an ergonomics perspective, the physical layout of a work area really depends on and should be designed around the task characteristics, and the capabilities of the employee. So we've already discussed the importance of defining and evaluating the type of task, including duration and movement, as well as considerations related to the task characteristics, like lifting, bagging, handling, walking, and reaching. But if you think about how most laundry rooms are laid out, there's an area for dirty laundry, a washer, a dryer, and an area for folding laundry, even if that area is the top of the washer or the dryer itself. Sometimes this area is in line, or they're beside each other. Sometimes it's in a square, and sometimes there's a work triangle. The shape and size of the work space available and the type of equipment, for example, is the washer a top load or a front load, or are the units stacked or side by side, can have an impact on the way the tasks are being performed. The layout of the laundry room will have a direct impact on whether certain activities can be performed and where they're performed. The weights handled will also be different if you're washing a comforter versus washing t-shirts. The distance you're willing or able to drag a wet comforter to put it in the dryer is very different than a couple of light t-shirts, and should have an impact on the proximity between the washer and the dryer. Finally, we should consider the employee's capabilities and whether a seated posture will change the capabilities. How much can be lifted and handled, both in a seated posture and in a standing posture? What range of motion is required, and can you achieve that range of motion from a seated position or from a standing position? What are the important biomechanical or psychophysical measures that have to be considered? And are these measures within the acceptable limits when the tasks are performed both seated and standing? In our laundry example, this may include calculating the internal forces of the low back when you bend over to retrieve wet clothes from the washer and put them in the dryer. Pretend for a minute that you'd like to fold clothes in front of the dryer from a seated position. Where would you put that seat? Would you have to reach across your knees to get the clothes out of the dryer? Would you have to bend down? Or would you have to twist your back because you don't have enough room for your legs in front of you? When the leg clearance is inadequate, these are some of the questions and concerns that may arise when you try to change a standing task to a seated task. The room layout and its effective use is important when considering whether a work task could be performed in a seated posture. Those task characteristics and employee capabilities are directly affected by the layout of the work area. When it comes to the question of reasonable, the court mentions the term feasibility, and that it could include ensuring no undue interference from other standing tasks, also evaluating the frequency of transition from sitting to standing, and assessing the impact of introducing a seat on quality and effectiveness. We will continue to use our laundry example and look at the way some of these items may come up during an ergo eval. One important consideration is the impact, when we look at the impact of introducing a seat, would be to ensure that it would not prohibit movement or function of the other individuals working in the same area. Also consider egress in the case of emergency, making sure that we have the required clearance around a seat so that other employees and the employee using the seat can fit and function in the workspace. In the laundry example, the impact of this analysis would depend on what other tasks are being performed in your laundry room. Is the laundry room a place where you keep your dog food or your animals' crates? Is the laundry room also a mudroom where everyone in your house comes in and they drop their items or they pick up their items as they come in and go out of your house? Is there an extra refrigerator or freezer in the laundry room for storage? These items and their associated standing and walking tasks would be important to consider when reviewing whether a seat could be provided and where it should be placed. Another feasibility consideration is to evaluate the frequency that the employee would have to alternate between sitting and standing. This assessment assumes that there is some portion of the task that could be performed seated and another portion of the task that could be performed standing. Accurately assessing the frequency that the person would have to stand up and sit down is important. We recently worked on a situation where an employee believed that they could work in a seated posture. In this case, an employee was working loading items in a tray and then placing those loaded trays on the conveyor. The conveyor was shared with other employees, and although it was located in front of the employee we were working with, the distance or the reach to the conveyor was great enough that they would have had to stand up to reach it, and so they couldn't reach it when they were seated. As a result, the employee, if the work was being performed seated, they would have had to stand up every 10 seconds to place a tray on a conveyor. So this would require standing up and sitting down 6 times per minute. Multiplying that out, that's 360 times an hour that employee would have to stand up, place the tray on the conveyor, and sit back down to load the next tray. Can you imagine working an 8-hour shift where you had to stand up every 10 seconds? Yeah, me neither. What if we had a work table with adequate clearance in our laundry scenario where you could sit down and you could fold some laundry? Sitting and folding smaller things like washcloths or socks and maybe some casual wear may be appropriate. But think about what would happen to your shoulders and your elbows and your back if you tried to fold a sheet while you were seated. It's likely that the clean sheets would at some point fall off the table or the couch and touch the floor and possibly get dirty. That would be a quality problem related to introducing a seat. Due to the size of the sheets, we would most likely have to stand up in order to fold them. What other items would you have to stand up to fold? Pants? Large bath towels? What other items could be folded seated? Now think about a typical load of laundry. How many of those items are in each load? And how many times would you have to stand up to fold an article of laundry and then sit back down? The number, frequency, and duration of seated tasks and standing tasks, and then the frequency of alternating between those two are one of the things that ergonomics and the courts agree should be considered. Finally, when any changes are made to a workstation, it's important to consider the impact of these changes on quality and productivity, as well as effectiveness. This is the part where an ergonomist who's trained in industrial engineering techniques is particularly well suited. They can evaluate the impact of the ergonomic changes while also using industrial engineering tools and techniques to ensure that there are not any unforeseen changes in a negative way to affect the quality or effectiveness of the task. It should be noted that ergonomic changes can actually often improve quality and effectiveness of the work task due to increased injury risk and improved consistency in work procedures and practices. A non-litigation example of improvements in quality and effectiveness is our work with housekeepers in a hotel. We performed ergonomic analysis related to how they approach their room cleaning tasks, including cleaning the showers and the bathtubs and changing sheets, and our results led to some recommendations related to standardizing the way they perform those tasks, as well as the tools that they used when they were doing that. After the implementation of these techniques and after the employees were trained, not only did their injury rates and their costs go down related to those injuries, but their guest satisfaction scores related to room cleanliness increased significantly. These wins for decreasing injury risk and improving quality are not an isolated case, and it's something that we see often. Ergonomic evaluations can be either proactive or reactive. In the case of suitable seating evaluations, reactive evaluations would occur after a case has been filed. Proactive evaluations help mitigate risk and should be performed as soon as possible on tasks that are deemed high risk. So taking a look at the tasks being performed in certain areas can yield a short, or sometimes not so short, list of targeted tasks. Reviewing these tasks to see if they meet the criteria for having a seat would make sense. In the case of our laundry scenario, it's highly unlikely that most of us will perform the washer and dryer tasks while seated due to the nature of those tasks, the weights being handled, the distances we're moving that laundry, and other factors. But it might be that sometimes the folding task would be performed seated. And so understanding when the task should be performed standing and when the task should be performed seated are important parts of any evaluations out there. Okay, so now we've reviewed the task and determined that a portion of them may be performed in a seated posture. What kind of seats should be considered? Are there pros and cons to each type of seating? Seats can generally be divided into three types: seats or low seats, high seats, and sit stands. Seats are typically lower and designed to have your feet on the floor or on a small footrest and are typically used for workstations that are around 30 inches or lower. High seats also have a flat seat pan and look like low seats, but typically require a significant footrest because the cylinder is larger. High seats may be used for working at higher workstations, and they may also be appropriate for providing a seat at a standing task in the range of 38 to 42. Leg clearance for low seats and high seats is critical, and when you use a high seat, you will definitely need a significant footrest. The leg clearance for those low seats and high seats is greater than that would be required for a sit stand because you would basically have to reach in front of your knees and your feet. So making sure that you have room for knees and your feet and that the feet are properly supported is critical when you introduce any type of seat. A sit stand is sometimes referred to as a butt rest or a lean stool, and one major con with using these is that they often require a significant amount of counterbalance because you're not actually sitting on them, you're sort of leaning against them. Often what that means is that they have to be bolted to the floor or you have to drill a hole in the floor and put the pedestal in it. So the ability to move around or adjust those seats based on where you're working is very limited. If a chair is introduced into a work area that is currently a standing workstation, please ensure that workers are trained in the use and the adjustments of seats, as well as when it's appropriate to sit and when it's appropriate to stand to minimize their risk of injury. Just to recap, evaluation should be performed to understand which tasks are being performed at a work location and the risk factors that are present. Understand also what impact, if any, the introduction of a seat will have in the work environment, and then understand what should be done to ensure that tasks can be performed in a manner necessary to meet both the business objectives as well as reduce the injury risk. Andrew, did you want to go ahead and jump in and add some other action items?
Yeah, I would add a couple issues too. From an employment law standpoint, it's really important to, as Brandy mentioned, to have an evaluation conducted of the workplace, and that evaluation, it can be done under the auspices of counsel if there's a concern about whether you actually want to use it in litigation or otherwise, depending on what you discover. But that evaluation can assist you in forming an understanding of the nature of the jobs throughout the company, especially if there's multiple locations throughout the state, and then use that evaluation to as a potential Exhibit A in defense of litigation. But also, as Brandy touched on, that evaluation, ergonomic evaluation, can be used to minimize injury by employees. That would reduce your workers' compensation claims. It can be also used to enhance the quality and productivity of the work. So there's a variety of considerations. One other consideration is that if an evaluation is done, there should be a reevaluation at some point as duties do change over time. Another consideration too is how you communicate the availability of seating to employees, and this is something that you'd want to discuss with your counsel. But if with your employee handbook, you may want to, for certain positions, provide a notice of the availability of seating that they can request. That's something that will need to be carefully considered, given that there are certain positions for which you do not want to offer a seat, where it's fairly clear following an evaluation that the provision of a seat just would not be feasible. Let's proceed to some questions. I know there were a couple questions that came in. Brandy, do you want to read? Well, actually, this question seems like it'd be appropriate for you, Brandy. Do you want to read that one?
Yeah, sure. So one of the questions that came in is related to, said, would the concerns and evaluation be different if the evaluation was for risk mitigation instead of after litigation has been filed? And the answer is that the results and the concerns at the end would be the same. However, with risk mitigation, we have time on our side. And generally, when, after lawsuits have filed, the dynamics within the organization have changed a little bit. And within the litigation context, the details of the analysis have to be greater because they have to be airtight for the case. With risk mitigation, we have time on our side, and we can do the analysis also that gets us to that end result. But there's a little bit of room for flexibility as far as how far down we have to drill down for those details.
And there was another question that, from a legal standpoint, that I wanted to answer. The question is, does the Supreme Court decision affect any requirement for providing seats during any downtime in work? There are in the wage orders two parallel requirements, and the one that we much discussed involved the nature of the work and the requirement for a seat as appropriate when performing work. The second concerns the requirement that employees be provided a seat, or that a seat be available in reasonable proximity to the work area when employees are not engaged in active duties. And that requirement was not expounded on much by the Supreme Court, but it was made clear that a seat needs to be available in reasonable proximity to the work area when employees are not actively engaged in duties. And so that will be a consideration that when evaluating your workplace, you want to consider whether a seat can be provided during the active duties, depending on the physical location and all the other considerations that we've discussed throughout the webinar. But also that there be a consideration about whether there should be an area where seats are available nearby for any downtime that the employee may have when he or she is not actively engaged in work. Well, I think that's the questions we have for today.
Andrew, there was one more question that came in, and maybe both of us could comment on that from our different respective views, I guess. That question is, what industries do you think are most vulnerable to these citizen suits, and what about the operations in those industries would make employers more likely to be targeted?